It is introduced, I believe, in Parliament with the
We
same.
have filed an affidavit, my lords, that new data protection bill, which might cover most of the issues, my lord, being heard. Lord, is being introduced subject to, my lord, administrative approval, etc., some formalities. In the second half of this session, the session has started from today, my lord. The second half would start from 13th.
Well, our request is that let the bill come, Malad, because it will be before you, and then the matter can be taken.
Because on behalf of the petitioners in the lead case,
Yes.
I'm opposing this application. This was mentioned to your lordships in September when the matter came up. It was meant at that stage there was no bill pending. The history of the last bill which they introduced, because in fact there's an order in this matter where in 2017 Mr. Mehta had informed the court that time when a committee was being set up that it may translate into a law. So that was 2017. Then even in September, it was mentioned that there could be a bill. The fate of the last bill was that the bill itself was withdrawn. And your lordship knows that even after a bill is placed, it sometimes may get referred to a committee, etc. There may be deliberations, etc. So the introduction of a bill itself, assuming what they say is correct, and I have no reason to doubt that they are proposing to introduce it, shouldn't defer or delay the taking up of this case. Your lordship will take up this case and then we'll see as to what is to happen in the matter. Let us open and conclude. We'll assist the court as best we can.
I'm in 502.2, where the issues do not pertain to the bill at all. The issues are threshold issues of reviewability of actions by private parties. So bill or no bill, that issue is before your lordship. So I'd urge your lordship to hear that issue.
I also place the corrected matter.
Have the statutory mechanism in before
Be an academic exercise.
Judicial review of what?
Of judicial review of actions by non-state actors. That's the issue before your lordship. That doesn't pertain to the bill in any way. It's not germane to
That
the.
is also referred to.
That's before your lordship.
Well, that non-state action
502
also part is also covered.
Even in the main petition that Mr. Diwan is leading.
Is it in connection with this WhatsApp thing?
Yes, exactly, my lord.
Malad, it
As a
doesn't deal
matter
with
of
WhatsApp.
The position
The
is
bill
what we are
substantially
advancing.
supports Mr. Diwan's submissions. I'm geographically sitting, Manoj, standing here. But my purpose is not that it might be, Manoj, an academic exercise in absence of any statutory framework before your lordship.
Whereas what will your lordship decide? Whereas in the absence of the formulations, whereas of the government, which are very complex formulations,
Whereas
in the context of the experience.
Because I'm sure the government will frame it. We've been waiting. Your lordships have placed the matter now in this month and it is coming up. So let us wait our turn and we will assist your lordships when the matter is called out.
One,
Yes.
sorry. You are right in saying that just because a bill is introduced,
Yes.
that it will immediately result in an act. You are right in that.
Yes. It may not, the bill may not carry.
May not carry also.
Exactly.
And it might be referred to.
And our grounds are independent of any statute being passed.
I would understand that.
Right.
But what we are trying to suggest,
Yes.
rather looking at,
Yeah.
is that a legislative framework,
Yes.
if it is available,
Yeah.
and if the government is contemplating it,
Right.
then should we now do this exercise because
Most definitely, according to me, yes.
these are not
Because
these
this
are
is,
not easy exercises to be done. So therefore,
no, I agree with
the
you. So,
government has taken a particular conscious call to introduce a bill. I think legitimately for a reasonable time, I think we can wait certainly.
anyway, I will make,
I'm in waiting. I'm just asking.
I'll make two submissions. This is a writ petition which relates to the year 2016. Correct. It's a 2016, and thereafter there's a judgment of the Delhi High Court which is in challenge in appeal here now before this court, before a constitution bench. So that will have to be considered on whether it is right or whether it is wrong, the validity of that judgment on the basis of the grounds which we put forward. Now, doubtless, as to what your lordship says, that if there is a statute which comes in at some point of time, it may have an impact eventually with regard to how certain persons who are operating, including WhatsApp, operate, whether they can trade their information or not. The bill which is in the public domain and available to us, etc., for comment, etc. And in fact, their last affidavit says that they are collating the comments and then they will synthesize them and then probably place them as a bill. That has no impact insofar as this case is concerned. There are generalities and provisions in the bill which have no direct impact as to the issues which we are proposing to canvass at all. But I don't want to second guess as to what the government eventually introduces and what eventually comes to be passed. I mean, that is not in our realm. So we have a case. It's been referred to a panel of 5 judges, a constitution bench. We are anxious to go ahead with this particular case. I'm not for a moment doubting that if a law eventually comes to be passed on data protection, it may have some impacts. But that's the nature of, that's the manner in which our system functions. You have laws, you have systems where the court pronounces on the law. But just now to short circuit it at this stage, I don't think is appropriate.
Well, just to add to that, because this bill has been pending since 2011, and even if today the bill becomes an act, then because what will happen is that
it's a new.
so since 2011 this exercise has been going on, and even if the law comes today, my lords, what will happen to the time where all this vacuum was there and privacy violations have taken place?
Mr. Diwan,
Because the
Yes.
previous provisions would be prospective only.
you are right in saying long pending, it has to be heard, undoubtedly to that.
No, and your lordship recalls in September, they made the same request. We said we'll put it in January. If no bill comes by or no act comes by, then we'll proceed.
You are right in saying, but once we have been informed about the bill is there, it will also assist us also in taking a final call after you come on record.
Your
You may make your submissions as to
How
what
will a bill, my lord, it's not going to decide on a bill.
ultimately
This exercise.
it will assist us also.
We have circulated issues. Lordships on call can examine the issues and decide whether they pertain to the bill. As far as,
What are the core matters?
yes, in 502.2 in which I appear, my lord, the core matter is WhatsApp's privacy policy, which the petitioners generally believe violates users' right to privacy.
I support them on that.
Now, in that context,
I support
in that context, there is,
in favor of the intermediaries.
in that context,
Here nor there.
in that
That's not
context,
the
there is the
issue.
bill, but there are threshold issues to the bill. One of those issues, which was
The
recently,
privacy policy is covered by the bill.
which was recently decided
And
by
this
the,
is not WhatsApp.
in a 5-judge bench, was whether
It's not
Article
WhatsApp
19 and
centric
21,
legislation.
was whether Article 19 and
It's nothing to
21
do with
is,
WhatsApp. It's
To
not.
go to that, immediate intervention is required because day by day, minute by minute,
One second.
the rights are being infringed.
Well, that's-
Their personal
Well,
data is being
My
disseminated.
learned friend should tell me one individual out of 600 million who says that this right has been violated.
it's a PI.
Not one.
But that's admitted
So
case.
let's not go into that.
It's a Mark Zuckerberg statement before the US Senate. Admitted case, there was data leak.
If your lordship
Cambridge
goes,
Analytica was a
it will be an academic exercise.
In a housekeeping situation, so much heat is being generated.
Understand?
Not at all.
The whole
But
exercise.
may I make a suggestion? Make a suggestion. Here we have interrupted an ongoing matter which is before the Constitution bench on a mentioning by the other side. Let us wait for this earlier bench to, we are the very next matter. When our turn comes up, we'll assist your court and be in a Yes, very well.
Middle of a, you're interfering in the middle of a year.
No, Manoj, we are just, Manoj, your lordships, we wanted to inform you that this is going to
That's
be a
right. That is-
commission, Manoj, and we will.
Only Manoj, one.
You're interfering with the partnered matter.
No, I don't.
No.
We are not here to interfere with any.
You know that. An indulgence.
Yes, sir.
Only one thing, Lord, for clarification. We would not, Lord, we are supporting the privacy policy and we are with the users. And we are not with the WhatsApp or anybody, but the bill, not the hearing before your lordships would be confined to either WhatsApp or, it is intermediary centric. Intermediaries are 7, WhatsApp, Twitter, Facebook, and large number of others, Lord, which we, Lord, perhaps may not be aware of. We'll, Lord, assist your Lord.
Primarily to
No, only-
WhatsApp and Facebook.
No, there is Google,
Seminal one before your
Insta,
Somebody is talking.
there is Twitter, there is Google.
Somebody is talking, just don't do it. Lord, question is of few weeks, Lord, I leave it to you. Because I say, Lord, it would be coming in the, subject to, Lord, the administrative, Lord, this thing, procedural issues, it would be coming in the.
Let us not do anything when we are in the middle of a partner. We are not going to do it on mentioning this man. Your address is after this matter is over.
Yes, grateful. We'll be here.
Yes.
My lords. My lords.
Yeah.
My lords, it is a matter of fact that the Joseph Shine judgment did not deal with any of the other statutes. It was only concerned with 497 of IPC and consequently 198 of the Criminal Procedure Code. Nothing beyond that. My lord, subsequently, a matter came by way of an appeal to this honorable court, where the provisions that the honorable court were concerned with were parliamentary provisions, but under the J&K Constitution, the Ranbir Penal, sorry, not the Constitution, the Ranbir Penal Code, where parallelly provisions of the Army Act under Section 63 were also in. My lords would see the judgment. The judgment part where the appeal was concluded, and it was held.
Which can be imposed as a result of 45. Take for example 45.
Yes.
What will
Cashiering
happen-
or dismissal, cashiering or dismissal,
That's it. We're just saying.
not imprisonment.
They invoke 63, 7 years.
7 years imprisonment under 63.
No, what, 45, what is the punishment?
Cashier.
That is cashiering,
Dismiss-
which is dismissal with dishonor,
You're virtually you're
dismissed with dishonor. With dishonor. Dismissed with dishonor, that's cashiering. And then,
where do you get that? Where do you get all that?
my lord, the definition of cashiering is not under this. If the, where are the?
You're saying it.
It's in 45 itself. Cashier, the word is used. It's a term of art so far as military is concerned. There's no
It's
definition
not
of cashier.
defined here, but it basically means you are dismissed.
Cashier is you dismiss, you don't get benefits.
It's an ignominious form of dismissal, and then, or to suffer such less punishment in the act. And if he's a junior commissioned officer or warrant officer, be liable to be dismissed or to suffer such less punishment as in this act mentioned. Now, that other provision for less punishment would be in 71. Lord 71 talks of D is cashiering, E is dismissal, F is reduction to the ranks or to a lower rank.
One more thing, you read 45, liable to be cashiered or suffer such less punishment as in this act mentioned. What is
That's 71. 71.
70? That is
So
C.
we have to look at less than cashiering or dismissal.
That is C.
So please see 71 D is cashiering, then E is dismissal,
71.
71, yeah. D is cashiering in case of officer, then E is dismissal from service, F is reduction to the ranks or to a lower rank or grade or place in the list of their rank in the case of warrant officers, and reduction to ranks or to lower rank or grade in the case of non-commissioned.
So what we are trying to tell you is, this is not exactly setup of a criminal trial, where the punishment usually is part of either imprisonment.
63.
There.
45 is not, even though it's by a court martial.
Therefore 45 read with 71E onwards. I mean, sorry, from E onward.
It can be reprimand. It can,
Of a disciplinary procedure.
yes, it bears the character of a disciplinary.
5 years of imprisonment.
So they always evoke 45 read with 60. They're all people who are convicted under 45 read with 60.
If they do it only on 45, what you're trying to say, 45 is either cashiering or something less.
Something less.
Not any punishment.
That's right.
It's a criminal trial. That's right. If you wanted to
But it's
understand.
through a court martial. Or through a court martial.
That's right.
One question, suppose if a man and a woman, take one, the man is an employee or both are employees, they are engaging in an activity constituting adultery in the premises of that very institution. And after the working hours or during the working hours or before the working hours. And then see whether you will say that since it is that particular act is decriminalized, they can do that with the impunity and then escape unscathed. Or whether you will say that the employer is free to take action, initiate action for an unbecoming act. What is your?
Submission is simply this. Insofar as conduct workplace is concerned, workplace belongs to the employer. There is nothing. The Joseph Shine judgment doesn't come in the way of the employer making a law.
So merely because that particular act is decriminalized, the very same action.
How? If there is.
See, that can also be a reason for holding them for an act which is unbecoming conduct.
My lords, let's take a simple example.
No, that is why we put this example.
I will take a
Very same action in the premises they are doing it. Can they simply say that this is decriminalized and therefore we can do it with impunity?
My lords, there is no question of impunity or otherwise.
So therefore there shall not be, for that particular action, there shall not be any action.
My lords,
Can't
it
you
is
say
not
that?
Submission to that effect.
If that acts constitute an act which is unbecoming of an employee, why you will say that no, they shall not be permitted to take appropriate action in accordance with the law?
My lords, our submission is not that. Our submission is simply at the context of the prayer that has been made by the applicant here. The prayer by the applicant is slightly different, if my
No,
lord.
we have indicated roughly that what we might do.
My lord,
That is acceptable to union. 197 is differently and particularly structured provision.
true, my lords.
It's not even a general offense like theft or something.
My lords,
Here is the permission of the husband or whatever for adultery, all that things are involved.
my lord,
And the reasoning of the constitution bench was that patriarchal elements in the provision itself.
my lords, if one were to look at Joseph Shine, shorn of everything else, there are two premises on which the provision is struck down. That provision is found to suffer from manifest arbitrariness in the manner.
Discrimination.
Manifest arbitrariness and discrimination, both, my lords. Manifest arbitrariness, therefore invoking Article 14 in view of the manner in which the provision was set. That only a certain person could be punished for the offense. Only at the behest of a certain person, there is a manner that person who claims to be the
Yes, but it would be speculative on our part to presume that this 45 and 63 would be employed only for this kind of
My lords, we are not.
offense.
My lords, may I just,
So what is your concern?
my lords, to be that, if we apprehend that once an order only to the effect that is given that the judgment in Jyotirshine did not concern itself with section 45 and 63 and equivalent provisions of the other statutes. Ground on the basis that there is a mandate of this court that that personnel who fall within the purview of the statutes could be prosecuted for offences equivalent of adultery, promiscuous acts, as has been prayed for in the application, and they would be proceeded against. We would be, were my lords to consider passing an order to the effect that no clarification is required in the terms that are sought, and that the Joseph Shine judgment does not concern itself with any other statute apart from section 497 and 198 of CRPC, I believe that there would be no issue.
We put a simple example to you. Supposing tomorrow an officer is charged under 45 with an act which amounts to adultery, as it is understood in 497. Correct? And it is described that this amounts to unbecoming conduct. Correct? Now, can the officer say, because 497 has been struck down, I cannot therefore be charged with a conduct which, for the purpose of the offence under section 497 under the Indian Penal Code, has been struck down, and therefore section 45 has become a dead letter. Unbecoming conduct must be something else.
No, my lords. That is not our.
Can you do that?
No, my lords.
Simple question we are putting. Can you do that?
No, my lords, because section 45.
If you can't do that, please clarify that.
That's all, my lords. All that.
You'll be in a worse position than what you were.
Yes. No, my lords.
We will clarify that. We'll clarify that.
My lords.
You are very correctly answered because you are led by your truthful estimation of what you understand.
My lords, all that I am saying is, would my lords consider just adding one sentence?
The example we gave you.
My lords, 45, there cannot be a so long 45 is invoked in a circumstance where the forces are able to make out a case that the conduct in question is unbecoming of an officer, that stands on its own plan.
No, that we'll have to be where you are little bit you are not answering. We are saying he is charged with the offence of unbecoming conduct of an officer, which ingredients are that which are borrowed from 497.
We'll take the simple example that there is promiscuous conduct by the person.
Promiscuous conduct, or it is adultery.
Yes.
We are saying adultery. We are saying right royal way. We are saying adultery, and they bring it under the 45. Then can you be heard to say 497 of the IPC has been struck down by this court? 45 therefore is eclipsed permanently, goes into a limbo, cannot come back ever, cannot be used. You go around merely committing adultery.
No.
Your officers and the rank and file, they are led to believe we have an officer who's thoroughly immoral. But nothing can be done about it. Huh?
No, my lords, that is not our.
No. What else do you want? What else are you suggesting?
I am not suggesting.
Are you not suggesting that
Not
exactly?
at all, my lords.
Yes.
I am in fact.
What should be disciplinary authority do when an officer, responsible officer, bound by the Army Act, commits adultery? Are you saying that their hands are tied, fold, you cannot do anything? Or are you saying they can be charged under 45? Please tell us, because
I will tell.
why
I
we
have
are
a simple
why we-
answer to that.
why we are telling you, the setting of 497 in the Indian Penal Code is of general application. Correct? Somebody who is not in an employment, somebody who is not with the armed force, that is a different thing. They have a different regime, which is the Army Act, Article 33. So if you cannot then say that we are outside the embrace of the discipline, which is sought to be enforced on us by statutory provision, which are different, which separately provide in very wide words.
My lords, my lords,
We will clarify that now. Now that we are clear in our mind.
my lords, 490, I understand.
You thought of only saying that it will not apply. You have made us feel that we should clarify.
My lords, the judgment in Joseph Shine does not talk about the 3 statutes which have been in connection with which a clarification is sought before your lordships. There is nothing in the judgment which talks about either of the 3 acts or about a workplace. An example was given that even in civilian workplaces, there is a requirement of disclosure of relationships internal. That comes from a right place of law. That is to ensure that there are no allegations of sexual harassment or an attempt to make.
Ghosh, we will ask you another question. Forget about state employment. Huh? You have private employment. Correct? In one of the items of misconduct, which is more carefully articulated, unlike this very loosely worded unbecoming conduct, is if a person commits adultery, action can be taken. Action is taken, and he is thrown off.
My lords, insofar as
What will happen? We're just asking you whether you can that employee say, sorry, even though actually I'm doing adultery, 497 has been struck down. You employer, you can't touch me. I will merely carry on with adultery, but sorry, your hands are tied. Can you say that?
My lords, let us look at Joseph Shine as a judgment first and see what are the consequences of Joseph Shine and what is the premise and the ratio of Joseph Shine. The Joseph Shine judgment strikes down 497 and consequently 198. In coming to that conclusion, it proceeds on 2 separate premises. One is manifest arbitrariness and therefore Article 40, where it looks at the construct of the section in question and finds that there is no rational nexus as to what the purpose it seeks to achieve and how the manner in which the so-called protectee of the section, that is the wife in question, is being treated under the section.
That's right.
The second construct, the premise was.
We'll just chip in with our understanding of Joseph Shine. Joseph Shine has not sort of say that it's a moral good.
It doesn't.
On the other hand, it says that it will continue to be a ground for divorce.
2 minutes.
So it is a ground for divorce.
Minutes.
Joseph Shine proceeded on with the understanding of Articles 14, 16, and 21. And the fact that the husband of the wife alone can make a complaint, 198. Wife cannot make a complaint. So you brought in Article 14, discrimination. You went ahead and you shut it down. It is void because it's one case of fundamental rights being violated. It is void. Apart from 497, we are telling you in the context of employment.
Well, I'm just coming to that. Because 14 is not the only premise on which it's struck down.
If it is so, then even as for the ground for divorce, it should not be.
2 minutes.
Why not? Even as divorce, it should not be.
The reason why
so
it
bad,
continues.
so good.
No, my lords. The reason why it continues to be a ground for divorce is that adultery is adverse to the marital relationship between a husband and wife.
Correct.
Is not questioned. That there is possibly a break in the relationship between the husband and wife and their continued relationship as a married unit.
Correct.
Is one of the grounds which a person who is impacted by the adultery of the other person can take for a ground of divorce is that I do not wish to continue living with you because you have entered into an extramarital affair and I am the party, who's the affected party, I do not wish to continue living with you.
Correct.
That is.
Therefore, it's something which goes to uphold the sanctity of marriage.
My lords.
It goes to it because the reasoning in Joseph Shine is that keeping it as a criminal offense does not, go to uphold the sanctity of marriage. If you're saying on the civil side in a divorce petition, it is necessary because if I lose bail, in my wife and then say that because she is living in adults, I will not have anything to do with it.
Yes, madam.
In the Hindu religion, in the Christian religion, it is treated as a sacrament. In the Mohammedan law, it is a contract.
Hindu marriage.
Correct. So there are different underpinnings to it, which we should
I do not deny.
entirely,
My lords, let's break it down.
we have seen murder cases which which have originated from adultery. We have seen the kind of, the strife that it has brought in, the disharmony with all, we have witnessed it. As judges, we have seen what happens, particularly when, marriages are torn asunder by adultery. What happens to children? I can relate to you any number of incidents. So it is, we don't.
My lords, let me not be heard as saying that I am taking the action of adultery lightly, or I am making a submission lightly on the actions and consequences of adultery. I am candidly submitting that I am not addressing the emotional aspects of it. We therefore are looking at a circumstance where there is an application that has been filed, where two questions have been put, framed for my Lord's consideration, and a prayer has been made.
Correct.
The prayer is to permit them to prosecute a specific direction whereby they wish to incorporate by a dictum of this honorable court promiscuous and adulterous acts within the provisions of section 45. My lords, may kindly see with me once the prayer.
Well, we were also about to request you to read the prayer. We are now half inclined to actually allow the prayer.
My lord would then allow me to say.
Read the prayer.
Yes, ma'am. My lord would come to page 27.
Yes, we are right. That's in front of us.
The persons subject to Army Act, Navy Act and Air Force Act by virtue of Article 33 of the Constitution, being a distinct class, any promiscuous or adulterous acts by such persons should be allowed to be governed by the provisions of Section 45 or 63 of the Army Act, Sections 45 and 65 of the Air Force Act, and Section so and so.
So tell us what is wrong with the prayer.
My lords.
Tell us what is wrong with the prayer.
This is by way of a clarification to the Joseph Shine judgment, which judgment does not pertain to, nor does it discuss any of the statutes.
It's exactly that.
Second, my lords, the provision in the question provisions or the relevant provisions that we are talking about do not identify any specific conduct. They pertain to certain conduct which they believe are impermissible in terms of the code that the military follows. My lords, it has to be determined on a case-to-case basis whether a conduct by a person would pose against the military's ethos. There could be a circumstance where that a husband and wife are separated and deserted for 15 or 20 years. There are ongoing marital disputes and a complaint is made. Were my lords to incorporate specifically in these provisions that any promiscuous or adulterous acts would be read into these provisions without looking at the facts and circumstances of the case, my lords would allow a barrage of applications to be complaints to be filed. Simply because there are parties engaged in a marital dispute, allegations would be made, and because of the mandate of this court, even the military officers will not have an option to evaluate on a case basis, and they would be necessarily required to input these provisions.
If you're saying that, would you have an objection if we clarify that in the decision of this court in Joseph Shine will not stand in the way of their taking action under section 45 and 63 in cases where unbecoming, so elements which are mentioned therein, including promiscuous and adulterous act, put it differently.
Would my lords require to clarify that?
Because the judgment is being cited by you.
My lords.
Not you means, whoever is.
My lords, nobody has cited a single judgment. There is not a single case that my lords would recall that on an earlier occasion, my lords had called upon the government to cite which are the cases where this issue has come. No affidavit has been filed to that effect, my lords. No case has been brought to my lords' notice where this issue has come up.
No, Ms. Ghosh, we can't be looking into how in a given factual scenario how the situation would play out in a disciplinary proceeding. Let's take it as a disciplinary proceeding, right? How the scenario would play out in a given factual scenario, that we are not required to contemplate here. We are all in agreement here that the judgment that we are talking about had nothing to do with these provisions of the Army, Navy. To that extent, you agree. That's a factual thing. The court had no occasion to look into those. Now, how they would play out by application of the Army Act and the Navy Act and the Air Force Act provisions, you don't have to.
My lords, I am ruling on the first part. In fact, my lords, a statement as my lords were.
No, even Miss Diwan was agreeable to have just that bit of a declaration. That's all.
My lords, we are contesting an order by this honorable court to the effect that there is no need for a clarification because the judgment in question did not deal with this provision.
That's all has to be said. Then why we are doing all the arguments then?
This was only in the context that in cases where they seek to invoke, that should be.
So how they play out in a given scenario, I don't think that is something.
I bow down, my lords. My lords may consider stating to that effect. Should my lords seek to do so? That the judgment in Joseph Shine did not deal with any of these statutes, and consequently, whatever actions need to be taken will be as per the provisions of law.
That's what we told you. Then you chipped in with a lot of objections to even that.
No, my lords, I was not objecting to that. I only wanted an additional clarification. Since my lords are not keen on it, I would respond.
Yeah. Who else is there?
Shall I just point out a few aspects?
That answers my preliminary objection. The only apprehension we have.
Who are you? Who are you?
Both of us belong to a category of officers to be convicted under 45 and 63.
What are the charge against you?
The charge against us is sexual relations with another officer. In my case, both of us are officers.
Okay.
The accused who is before your lordships and the lady with whom is accused of having.
Does the lady officer happen to have a husband?
Obviously she happens to have an husband.
The marriage is not yet dissolved.
In my case, what happens is 6 years of matrimonial disharmony.
Correct.
No complaint by anyone. Talks failed. She writes a letter to them saying that the army saying that he is indulging in extramarital affairs, pending all these divorce disputes, and I am out. So that's the apprehension my learned friend also pointed out. In 6 years, nothing has happened.
That's right.
I am serving my army. After 6 years, when the divorce talks breaks, and a letter is written, and that's how I am pulled into this. But I have no problem. In fact, we can't have an argument with the court when the court is giving a clarification that Joseph Shine did not deal with these sections. Anything more than that, my lords, becomes an advance ruling on the validity of 45 and 63 with all due respect. That is what they wanted. The tenor of the application was that's all. Anything more than that is an advance ruling on the validity of 45-63, which we may or not challenge once our orders of court martials are confirmed. So, if your lordships is to clarify that no clarification is required in the circumstances of the case, given that Joseph Shine did not deal with either.
Then who else is there? Alishan Raj.
I am, yes. But I am on a lighter note. But I am reminded where I read Franz Kafka, the novelist elsewhere, who accused lawyers of making 10,000 words over a single document and thereafter calling it as a brief. And this applies to arguments as well, as a brief.
Yes,
as a brief. But this applies to arguments as well. Anyway, I don't intend to face that charge at all, in making my submissions. I will be very brief. I am straight away coming to the point.
It's already charged me. That's another.
Yeah, that's the only problem.
No, I am not charging my learner friend. It's a general.
Raj, you say that you will be very short. Don't say I'll be very brief.
I will be brief. I will be literally brief. Yes.
Who are you representing?
I did not intend to. Ms. Madhavi was not in my mind at all. While I was making the submission, I was making a very broad general submission. She was very brief. She concluded before lunch. I don't accuse her at all, because she is the petitioner. I am on a better wicket actually. But I would Now coming to the aspects.
Who's your client? Whom are you representing?
Joseph Shah.
I represent Joseph Shine.
Oh, you are the original petitioner.
I am the original petitioner. That's why, my lord, I was in a rather showing a bit enthusiasm to defend the judgment.
No.
Now, my lord, I would point.
Asking whether you are an army man.
I am not an army man. I am not an army man. But I may make it very clear that Joseph Shine may not be understood to have decided anything with respect to the army persons or defense person or any of these 6 provisions in the 3 defense enactments. Your lordships are absolutely right. But the Joseph Shine did not deal with it. The prayer also is in the present application. In the present application says, the prayer in the present application, as it has been read over several times, that the person subject to Army Act, Navy Act, Air Force Act by virtue of Article 33 of the Constitution of India being a distinct class, any promiscuous or adulterous acts by such persons should be allowed to be governed by the provisions of Section 45 or 63 of the Army Act, Section 45 or 65 of the Air Force Act, 54(2) or 74 of the Navy Act. But I may say that this was not dealt with. That's a correct statement on facts. Joseph Shine did not deal with any of these provisions, but I should fairly concede that. But the point is, the problem is, when they file a clarification of something which doesn't require a clarification, that is slightly problematic, and that will set a bad precedent. I may my counterpart is there, Radhamani, Advocate Radhamani is there, she will hand over this judgment. One recent judgment of this honorable court in clarification may kindly be noted. Would your lordship kindly just see that, that's a judgment reported in Live Law 2021, because it is not reported in SEC or in any other journal. On clarification. Lordship got it, my lord?
No,
That judgment is Live Law 2021, Supreme Court 564. But this is specifically on the issue of clarification. First of all, the court says, but paragraphs 8 to 12 may be relevant. Paragraph 8 to 12 may be relevant.
Then Supertech.
In Supertech, a clarification petition was filed. And then, relying on Gurdeep Singh Uban, but an earlier judgment of this court said that you cannot file a clarification application when it resembles a review, at least in parts. Review may not be necessarily the review of the whole judgment, because as your lordships are aware of, going by the scheme of the Supreme Court rules, review is decided generally by circulation. It is generally by circulation, unless it is otherwise ordered by the bench. So that is the format of Order 40 Rule 3, as well as the Supreme Court rules. Lord may kindly see in paragraph 8 of this judgment in Supertech, quoting Justice Jagannatha Rao, Gurdeep Singh Uban was extracted. We next come to applications described as applications for clarification. Lordship got it? Page 9 of that OP, paragraph 8. Lordship got it?
Yeah.
Yes. In successive decisions, this court has held that filing of applications styled as miscellaneous applications or applications for clarification or modification in the guise of a review cannot be countenanced. In Gurdeep Singh Urban, Justice M. Jagannatha Rao, speaking for a 2-judge bench of this court, observed, we next come to the applications described as applications for clarification, modification, or recall of judgments or orders finally passed. We may point out that under the relevant rule, 41 of the Supreme Court rules, sorry, it is 15 of the Supreme Court rules, Excel, 1966. A review application has first to go before the learned judges in circulation, and it will be for the court to consider whether the application is to be rejected without giving an oral hearing or whether notice is to be issued. Then Rule 3 was extracted. Rule 3, unless otherwise ordered by the court, an application for review shall be disposed of by circulation without any oral arguments, but the petitioner may supplement the petition by additional written arguments, etc., etc. Then my lord, another judgment. Paragraph 18 of that judgment also may kindly be taken note of, as extracted, page 10. We therefore agree with the learned Solicitor General that the court should not permit hearing of such an application for clarification, modification, or recall if application is in substance one for review. In that event, the court could either reject the application straight away without cost or permit withdrawal with leave to file a review application to be listed initially in chambers. But this is the general settled principle which has been followed throughout by this honorable court, by different benches of this honorable court. Page 9 also tells the same thing, where another judgment, Ramchandra Singh, was extracted, which followed Gurdeep Singh Awan. And then paragraph common cause, also Sahira Sahibullah Sheikh versus State of Gujarat, telling the same thing. Paragraph 10 talks about another judgment, Rashid Khan Pathan. Then coming to 11 and 12, which is the latest pronouncement on this clarification application. Paragraph 11 may kindly be seen. This is the paragraph 11. The attempt in the present miscellaneous application is clearly to seek a substantive modification of the judgment of this court. Such an attempt is not permissible in a miscellaneous application. While Mr. Rohtagi, Learned Senior Counsel, has relied upon the provisions of Order 15, Rule 6 of Supreme Court Rules 2013, what is contemplated herein is a saving of the inherent power of the court to make such orders as may be necessary for the ends of justice or prevent an abuse of the process of the court. Order 15, Rule 6 cannot be inverted to bypass the provisions for review in Order 27 of the Supreme Court Rules of 2013. The miscellaneous application is an abuse of the process. The hallmark of the next is important. The hallmark of judicial pronouncement.
We have seen it.
Yes. All that I am saying is, but I will just read this paragraph just for the purpose of conceptual clarity.
Just 1 minute, 1 minute, 1 minute.
After entertaining that.
Yes. Please.
See, so by the principles laid down by this court,
Yes.
absolutely, we agree on the principles.
Yes.
No discussion.
Yes.
But kindly see this particular order which you have cited to us.
That I understand. Yes.
What is the prayer?
Now see the prayer quoted in paragraph page 1, para A.
Yes.
The prayer was demolish part of tower number 17.
Yes. Yes.
Okay. This is the they want a modification that
Correct.
demolition take place part of tower 17. Now come
Correct.
turn to the page.
Correct.
The division bench of the High Court said demolition of tower 16 and 17. No
Correct.
part of 17. Okay.
Yes.
And
Yes.
come to this court's order, which has been referred to a para 185 in para 2 itself, Roman 3.
Yes.
Demolition of tower 17.
Yes.
Nothing part without para 17, tower
Yes.
17.
Yes.
Now, this reference,
Yes.
if the miscellaneous application is filed,
Yes.
they look here, you might have considered tower 17 for demolition.
Yes.
The High Court has considered and deliberated for tower 17.
Yes.
This court also considered for demolition for tower 17, but now make a modification that
Absolutely.
part of tower 17 will be demolished.
Absolutely.
Can be permitted.
That's
That's
right.
why the court said you can't file an application for miscellaneous application for
That's
clarification.
right. No,
Here, there's
that's,
nothing like it. Here we are dealing with a matter where there is no subject matter available before the court.
correct. But it
And
is
you-
usually said. I agree, my lord. I cannot disagree with when your lordship say this, because there are no precedents on facts, as it is generally said. Precedents are only on law. Only on law.
But in this very judgment, in para 4, it is absurd. A constitutional court cannot remain entrenched in a precedent or the controversy relates to the lives of human beings. The very same judgment,
Correct.
signed judgment in para 4.
I don't say for a moment, or shall I just clarify my position? I don't say for a moment that in no eventuality a clarification. Even recently, your lordships clarified, my lord, that in the living will case, in the active passive euthanasia. Your lordship did it, and that was required to be done. And but the very many persons were rather rescued because of that clarification. The impediments were removed. I don't say, I may not be taken as saying that a clarification is always impermissible. That's not my argument. The argument is rather reflected in paragraph 12 of that judgment. I will then come to my proposition. Paragraph 12 of that judgment, Your Lordship may please see. The hallmark of judicial pronouncement is its stability and finality. Judicial verdicts are not like sand dunes, which are subject to the vagaries of wind and weather. A disturbing trend has emerged in this court of repeated applications, styled as miscellaneous applications, being filed after a final judgment has been pronounced. Such a practice has no legal foundation and must be firmly discouraged. It reduces litigation to a gambit. Miscellaneous applications are becoming a preferred course to those with resources to pursue strategies to avoid compliance with judicial decisions. A judicial pronouncement cannot be subject to modification once the judgment has been pronounced by filing a miscellaneous application. Filing of a miscellaneous application seeking modification or clarification of a judgment is not envisaged in law.
I think the context of the prayer in that application.
Yes, I understand. I understand. Every decision, my lord, that exactly, my lord, what I would say about Joseph Shine also. Joseph Shine, as your lordships rightly observed, did not pronounce upon a person's culpability.
Your appearing can be put to you because you're the person who is who was responsible for bringing about that judgment in that manner of speaking. If in a section 45 charge proceeding,
yes,
the ingredients are exactly that he committed adultery.
Yes.
Will the Joseph Shine judgment stand in the way of the
Yes.
army authority taking disciplinary action, which is essentially a disciplinary action because the result is going to be cashiering?
Yes.
It's going to be ending up in a jail.
Yes.
So, would there be any insuperable obstacle for the authority in doing that? Just we wanted to know what's your dilemma.
My answer is crystal clear. There is no impediment created by Joseph Shine in such a course of action. Your lordship can even refer to this as my submission. There is no difficulty in that. Because I want to be fair on that. The point which I am making is only this. But the problem is something which is not there in Joseph Shine. Now I will come to straight away to the point. Something which is not there in Joseph Shine or in any judgment for that matter. Now the people across the country will be citing the judgments of this honorable court to either distinguishing it or, my lord, relying on it or, my lord, saying that it is not applicable to the facts of the case, etc., etc.
Yeah.
But will that give rise to a cause of action for clarification of the judgment cited is the question, precisely. But there will be hundreds of occasions where Joseph Shine is cited or distinguished or relied on. So, because somebody cites Joseph Shine or distinguishes Joseph Shine or relies on Joseph Shine, rightly or wrongly, can that give rise to a clarification application is my respectful question which I ask myself.
You see, there is another thing.
Yes.
Why they perhaps came in. Perhaps what the condition is because they might have come here with this.
Yes.
They perhaps want a message from the highest court, and that will be in strength.
Yes.
That what has been held in Joseph Shine.
Yes.
Not come to the rescue of members of the armed forces.
Correct.
If they were to, as you very correctly and fairly pointed out.
Yes.
If they were to be charged under section 45 or 63.
Yes.
They can be proceeded when there is no obstacle.
Yes.
That is what prompted them to come in.
Absolutely.
And even, it is unlike, we are not modifying the judgment.
Yes.
Like, since the court did not deal with Joseph, I mean with the Army Act, we are
Yes.
not modifying the judgment at all. We are only
Yes.
saying that was
Yes.
rendered in the context of, and therefore it will not apply. Even to that extent, we can go.
Correct.
But
Shall
we
I
are-
just, I perfectly understand what your lordships are thinking. I just perfectly understand, but I don't. It may not be taken, my lord, as I am opposing what is coming from your lordships. But I essentially agree with that. The point I am making is slightly, my lord, in a different context. The point which I am making is whether, my lord, a clarification, allowing a clarification as has been sought in as a general proposition, what will be the impact of that clarification in individual cases is something which your lordship may kindly consider. I am only on that. Nobody.
We open all the contentions of the
That's what I'm saying. That, and I will just put it in this way. Two judgments for illustrative purpose, not for precedential purpose. Two judgments that I have given to Advocate Radha today for illustrative purpose. Where in army, in defense, one is an Indian judgment of dishonorable court 2019 13 SEC 723. I'm not citing this as a precedent, I may make that caveat. And the other is a US judgment, Paras versus City of Roseville. Two judgments. I will come to the first. This is a case where I will just clarify my argument. This is a case where an army officer was proceeded against for bad conduct. What is stated therein is disciplinary proceedings were initiated stealing affection of brother officer's wife. This, just for illustration, I am telling this.
That's right.
Pardon me, Lord.
So that's right. I mean, you've seen that. So that can be done.
That can be done. Then what I am saying is, in this case, but despite this allegation, this does not say specifically about any of these.
You have to prove the allegation. You have to prove the allegation.
Prove the allegation, and if it is not proved, even in departmental context, it's an illustrative case where allegation was raised something akin to adultery.
I mean, these are all basic assumptions. You have to prove that case.
That's what I'm saying. That's what I'm saying. So in an individual case, no,
we are not going into that area at all.
No, that's what I'm saying. Your lordship may not go to that area is my submission. That's what I'm saying.
We are relating to establishing the case. That's distinct from whether you can make out a case.
Yes, my lord.
Distinctions.
Correct. Yeah. The point which I am trying to place, my lord, in this Paras case, the point is only this.
The only thing we are going to say that does not apply is not intended to apply.
Very well.
Do it the way you have first.
Individual cases, this should
Although
not
my
apply.
learned friends have perhaps been more persuasive than I have on this, so my lords would consider, because they have very fairly stated that the 45 and 63, my lords, I can
We're
still
not in
make.
the contemplation of the.
But not only not in the contemplation.
No.
There's an application maintained.
Shall I just point out one aspect, one single aspect, which may be slightly relevant?
Okay.
This is the point. Just your lordship, Justice Joseph was pleased to ask three pertinent questions, citing three examples. One, when there is consent. Two, when the act is involving intercourse. The point, that's why where I was trying to interfere, in the sense that I just wanted to make a point out of those questions. The point is this: it is not on account of the decriminalization of adultery in Josephshire that it happens. The autonomy of these three defense enactments and the 6 provisions which the learned ASG has been pointing out are independent of section 497 even before decriminalization in Josephshire. It is independent of it. Therefore, what I would submit is that tomorrow a private employer also can come here and say that my employee is not in a good conduct. So I expect that she may in future rely on Josephshire. So please give an anticipatory declaration. That a constitutional court will not give is my submission. Like an anticipatory writ, an anticipatory declaration or order also is impermissible, is my submission.
It's an application filed by the Union of India, is it? Yes. Union of India. Seeking the following clarification. Page 27 of the application. Applicant is seeking clarification of the judgment which is reported in 2019, volume 3, SCC, page 39. It must be noticed that the applicant was the sole respondent in the said case. Paragraph B. The reasons which have driven the applicant to seek the clarification are as follows. In the case of the applicant, that this court has undoubtedly proceeded to find section 497 of the Indian Penal Code as unconstitutional as it offended articles 14, 15 and 21 of the Constitution. However, it is the case of the applicant that officers of the armed forces are subject to statutory provisions, namely the Army Act, the Navy Act, and the Air Force Acts. Our attention is further drawn to Article 33 of the Constitution. It reads as follows, extract. It is the case of the applicant that the impression, an impression has been generated and is sought to be perpetuated, that in the light of the judgment of which verification is sought, nothing more would survive, even if a case is made otherwise under relevant provisions of, I just say hereinafter referred to as the Acts. Hereinafter, I mean, under the provisions of the Acts in question. Srimati Madhavi Diwan, learned additions officers, there are two appears on behalf of the applicant, would address the following submission before us. She drew our attention as an illustration to the provisions, the following provisions of the Army Act 1950. Chapter 6 deals with offences. Thereunder, our attention is drawn to section 45, extract 45. Further, she draw the attention to section 63. Finally, you should draw our attention to section 69. She would immediately point out that in the light of the judgment of this court, in so and so, since section 497 of the Penal Code has been struck down as unconstitutional, and it being a civil offence within the meaning of section 69 of the Act, it may not be open to the authorities to proceed against an officer within the meaning of section, under section 69. That's what you said. However, it's a further case that will not preclude the authorities from invoking the provision section 45 and or section 73 of the Act.
63.
63 of the Act. Okay. This is why we take, if we go and preserve, we commit all kinds of mistakes. There are similar provisions also in the Navy Act and in the Air Force Act. It is not sufficient that the word adulterous acts would bear the meaning which is assigned to it in the dictionary. So also the word promiscuous, and it need not be found integrally connected with section 497 of the Penal Code as such. The members of the armed forces, according to a class apart. She also drew our attention to the objects and reasons of the act. It is pointed out that the act was enacted, the law was enacted to provide for an exhaustive code. It is a complete code. It provides for self-regulation. According to her, the decision of this court in Joseph Shine must be viewed in the context of the institution of marriage. It was not rendered in the context of a workplace. Expanding further, the Learned Additional Solicitor General would point out the setting in which the armed forces operate constitute a unique workplace. Discipline among the members of the force is a matter which is indispensable. Discipline would indeed be eroded, according to her, if the high models announced to be occupied by members, by the officers, is diluted. The obstacle in the authorities invoking section 45 and 63 of the Act, with as also the corresponding provisions in the provisions in the corresponding Act, the corresponding provisions in the other two acts, will ultimately result in a situation where, in sensitive forces as the armed forces are, it would engender and breed gross indiscipline. The forces which are to always act as one and proceed on the existence of a sense of brotherhood would break down. This is not what it was in the contemplation of this court, and it grounds section 497 of the Indian Penal Code unconstitutional. Section 497 has been struck down on the basis that it offended articles 14, 16, and 21, 15 and 21. The court, it is contended was distressed by the resort to values of a bygone era, bracket the Victorian era. And the considerations which persuaded this court to hold section 497 are not germane for the purpose of deciding on the validity and legality of actions taken under sections 45 and 62 of the Act.
63.
Sorry, 63. She, in fact, did point out that there was an element of discord even in the matter of the right to privacy, which has been advocated in one of the judgments, in the judgment of one of the learned judges, whereas it has not been so canvassed in the judgment of another judge. There is a command structure in the armed forces which it is indispensable to maintain. Such command structure would be impaired and disturbed. She would, in this regard, focus her, seek to ask us to focus our attention on the word what is that word? Inappropriate behavior. Unbecoming conduct in section 45. She would submit that in a case where the officer is charged with what is unbecoming conduct and which consists of an act of adultery. Nothing can stand in the way of the authorities taking action. Importantly, pertinently, she would also point out that the provisions are gender neutral. A voice which was, and it does not suffer from the vice of being not so, as found by this court when it struck down section 497 here. Or it may be man or woman who acts in a manner which is found to be unbecoming can be proceeded therefore under section 45 of the Act. Equally, she drew our attention to section 63, 63, and points out the importance of the words military discipline besides good order. In other words, any act or omission which is not specified in the Act is found to be prejudicial to good order and military discipline would invite action under section 63. She even went to the extent of pointing out that it can lead to a mutiny. She would therefore point out that in this court may, and she would further point out that the Union of India is faced with the following situation. Action is taken under section 45, 63, Institute, section 3 of the Act. It is being challenged. The mode of contention raised by the officer is that the action is tabooed by virtue of the judgment of this court. This has led to a number of cases piling up. There is a certain amount of chaos. This doesn't conduce to discipline being maintained in the armed forces. But we've also had benefit of hearing. So please take your name.
Ananya Ghosh.
And Parmeshwar. They are counsel who appear for intervention. It is pointed out that by them that the application for clarification may not be allowed. You must say one more thing. Must be the one rather elections or surface. That this court may at least please declare that. We have at least clarify that. the judgment of this court was not concerned with and dealing with the provisions in question under the acts.